I have no issue with this. The letter by the clerk dated 20th August 2024, neither with the Speaker's Gazettement, which is also dated 20th.
Yes.
So there's no issue to that.
There's no issue, Your Lordship.
But the voting took place on 21st.
Your Lordship, for the reasons that I have mentioned, I've just mentioned, that when that division and voting exercise takes place,
Yes.
it is only upon conclusion of business, Your Lordship, that it is taken that day is complete.
So why not just gazette it 21st? Why not date also the letter 21st?
Because, Your Lordship, it is part of the business of that day. It has not terminated.
The petitioner is saying this is proof of a predetermined outcome. So that these letters were sitting in someone's draft folder, if I understood the example that was given, and they were just sent out.
Your Lordship, far from the truth. And for the reasons I've just given you.
Let's go into the affidavit so that let's go into the first affidavit by the clerk. Don't worry, your time is not running.
And remember, Your Lordship, at paragraph 33.
Yes, just read it.
Paragraph 33 of my reply. It says, by way of a Gazette notice dated 20th August 2024 and published on 21st August 2024. Your Lordship.
The publication date is not at issue.
Yes.
Does the clerk, because I want us to be on the same page,
Yes.
does the clerk, your deponent, in that first affidavit where he addresses that issue quite at length, does he give the explanation you're giving me?
Your Lordship, the explanation has been given. It is from paragraph 46.
Yes, just read it.
That in response to paragraph 29 of the petition, I wish to state that at the time the House was scheduled to adjourn, the Speaker of the Senate had put the question on the charges against the governor, and division was in process.
Just a moment. When I read those paragraphs, that paragraph 46 onwards, my understanding was the clerk was trying to explain why the vote continued into 21st, but was not explaining why his letter and the Gazette notice were dated 20th. That is my understanding of those paragraphs. So is there anywhere where, because this is a question of fact, where a deponent, it's the same deponent for both affidavits, says we dated it 20th, not because the decision had been made on 20th, but because of this is how we do things. Is that there?
No, Your Lordship, I'm not seeking any explanation of that.
My Lord, if I may.
Yes.
Perhaps I can provide some context into that. My Lord, besides being an advocate of this court, my Lord.
But now you'd be testifying from the bar, which is what I'm trying to avoid.
My Lord, perhaps I can give some clarity to the court.
Yes.
It is a long-standing parliamentary procedure that any decision of any legislature, leave alone the Senate, is actually captioned and actioned on the day it was made. A long-standing custom, my Lord, you may find it in X's Mill book, which are on parliamentary customs. Majority actually of parliamentary customs and practices, they are not codified, but they are actually legislative processes that are actually provided in customs of the UK Parliament. The essence is that what my colleague is trying to give context to is that the moment the division bell is rung, you may look from the answer and find that the Speaker orders the Sergeant at Arms to draw the bar. The significance of that means that
Yes.
nobody or no member can leave the chamber, no member can actually enter the chamber, and time freezes. That's the essence. Time freezes, my lord.
Now,
so in the essence,
yes,
that a division bell is rung, and until that bar is actually drawn back, that time that is provided there will be captioned on the date that the bar was actually drawn. And
But
in parliamentary custom, my lord,
yes,
the office of the clerk reports a resolution on the date that resolution was done. For what my learned colleague is
but the resolution was done on 21st.
No, my lord. That's where
The voting indicator
Yes.
there's a timestamp. The timestamp says it's about 40 something minutes past midnight. It is on 21st.
My lord, it's what we are bringing. What we say time actually stops is the day that the division bell was rung, which was on 20th. And parliamentary divisions actually can extend even to a whole day, because there are instances whereby a parliament will not adjourn until a decision is made. That decision will be made on the day that the division bell was rung, which was on 20th, my lord. So any decision that was made by Senate on that day was actually made on the 20th. The office of the clerk...
Just a moment, Council. Just a moment, Council. I deal with Gazette notices almost daily. And I think as advocates, you also deal with Gazette notices. This seems very, very peculiar, because when we look at letters, it is dated this. That is the date we presume someone wrote it. When you're speaking to an external person who may not understand, especially a Gazette notice, who may not understand the arcane English parliamentary procedures, wouldn't it be better just to date it? And then what evidence do we then have that what the respondent is saying is not correct? Sorry, what the petitioner is saying and what the respondent is now saying from the bar are not correct.
My lord, I do understand the confusion that is there. For purposes of clarity, my lord, I understand where the court is coming from. For persons who may not actually be proficient in legislative processes, the resolution is customarily dated on the date that decision was made. And that parliamentary day, a parliamentary day, my lord, is
Yes.
different from an ordinary day. And you'll actually see, even from the standing orders, they define days differently as in the context of a parliament. So, my lord, that means...
I'm familiar with that parliamentary business day,
Yes.
even in Westminster, especially in Westminster, a parliamentary business day can even be a week. That I get. But why then for external communication to the rest of us who know a day ends at midnight, begins at midnight? Why then tell us a decision was made on the 20th? We don't care, as a Mwananchi, we don't care about arcane
Yes.
Westminster principles. We just want to know the date when a decision was made.
Thank you, my lord. You have to look at the context. To whom is the Speaker Senate making that communication to? He's making that communication to the County Assembly of Mayor, which is another
the clerk.
Yes,
Maybe
the clerk.
I can give you that. I can give you the clerk was speaking to another
Clerk.
who may also know the.
For the clerk,
But what about the Gazette notice for the rest of us?
for purposes of the Gazette notice, I let actually my colleague highlight further on that. But my lord, Perhaps let me give it to my co-counsel, and he can shed more light on it.
Okay. But then your time has been off, so you've not suffered any prejudice. Yes. Just a moment, counsel. You'll come in after.
My name is Kawira.
Yes.
My lord, the way I understand it is that a parliamentary day is not an actual calendar date. We all agree on that.
Yes. A parliamentary business day is not the same as a
calendar
calendar date. Yes.
And the way I also understand it is that the resolution, which is the resolution of parliament, is dated on the parliamentary day on which that resolution was made, such that the communication to the external world, of course, council has qualified the one to the assembly, but even the communication, the Gazette notice that was published in the Kenya Gazette, that is a communication as well. And I think there would be a discrepancy if the communication to the clerk was to bear the parliamentary business day on which that resolution was made, but the Gazette notice that is published for consumption by the public bears the calendar date. So for all intents and purposes, my lord, the way I understand it is that a resolution, whether it is being communicated to Parliament, to another legislative body, or even for the consumption of the public, is dated on the parliamentary day on which that resolution was made.
I'm looking for that Gazette notice. I've gotten a little bit turned around. Councillor Ngoya, which volume is it in? So, respondents replying affidavit. It's an extra. So towards the end. Sorry, what page number?
In our volumes,
Yes.
of course I don't have my computer.
I was check page 2,207. 2,207 of this.
Okay. Page 2025.
Let's get to this place. I have this one. I'm ready.
Which volume number of the respondents is that?
I don't have all the volumes to do with that's my
Because the last volume I have is a volume number 4 for the respondent.
page 2045. They were sequential.
Yes, mine ends at 1736. I suspect there's a volume number 5, which I don't have in hard copy. Perhaps. No, theirs would have a. These are only for the petitions. Does anyone have a copy of that Gazette?
I have a copy.
Yes, that's all I need to say.
I want to make a comment on what my colleagues have been saying all along.
No, this is not the Gazette I'm looking for. I'm looking for the one dated 20th of August. Don't worry, I did look at your notes, so I don't have advance notice of what you're going to submit. The Gazette notice dated 20th August.
But I have it on my laptop.
Yes, I'll accept a laptop. first line, because this was my recollection. First line. That's why I separated the clerk speaking to the county assembly and this other one. It is notified for the information of the general public. Then that and gross misconduct, gross violation of the Constitution, gross misconduct, abuse of office, dated the 20th of August 2024. Thank you, Council.
I just like to make one comment, my lord.
Yes.
Your question to Mr. Mkele was simple. You expanded the scope of that question. The question to me was whether, as I heard it, whether the clerk at any place in his supplying affidavits explains why he dated it 20.
Yes.
And the answer, as I got it from Mr. Mkele, is that there is no explanation of the clerk. So that, I think the answer is there. The only challenge is when my colleagues now begin explaining from the back about parliamentary tradition, first without asserting the source of that expertise.
They said AXA in
But if we have to take them for their word,
yes.
then one will have to look at the petitioner's volume number 1A,
Yes.
page 367, which is Parliament's own Hansard.
No, that is not in doubt,
Yes.
Council.
So that Parliament's own Hansard shows that Parliament acknowledges actual times and actual dates. So it's a parliamentary own document. If my colleagues want to tell me that the clerk of the Senate communicating with the clerk of the county assembly would have some understanding of parliamentary time, there will be no clearer understanding of parliamentary time than the Senate capturing its own records in its own Hansard. And they tell us 21st August 2024. That's the understanding of their time. And more importantly for me, there's then the parliamentary business, as the debate and resolutions.
Yes.
Then there are the administrative communications of those decisions. Those are two different things. In this court, for example, my lord, you will make an order on a particular day. That order will permanently remain made on a particular day. But the moment the registrar is extracting that order, he will communicate the date when that order is issued, as and when we get along, so that becomes critical for communication to the public.
So I've not recorded any of that. My question, Councilor Mkele, is the Gazette notice begins, it is notified for the information of the general public, and then it's dated 20th. The purpose of the date, to my understanding of a Gazette notice, is to say the date it was issued as such, and it is for the general public. Can the general public then be expected to know these arcane Westminster traditions? Or can we then say that that decision was made on the 20th, calendar date 20th?
Your Lordship, I still maintain the decision was made on the 20th. In fact, Your Lordship, if you looked at the specific allegation, was that the debate took place on the date not gazetted.
Okay. All right. So let's leave that. Let's leave that. Let's leave that there. The only thing I've recorded for all that, it's just so that I'm settled in my mind. A division is only called when it is a matter that affects the county, so that we go into delegations. That was the last thing that I recorded.
Yes. Your Lordship, just to pick up from where I left,
Yes.
that the delegation means that every senator in charge of a county delegation has to vote, Your Lordship.
Yes.
And remember, Your Lordship, that happened for the second division exercise, the one for voting on impeachment, as well as voting on the debate for limitation of time, Your Lordship. Your Lordship, inevitably that means a lot of time is spent on that exercise, Your Lordship. And in
Yes.
that understanding, Your Lordship, and on the basis of the rules that I mentioned, Your Lordship, then interruption can only occur after the business of the day is complete, Your Lordship. Your Lordship,
You have about 20 minutes. If this is not a very controversial issue, that they will spill over
yes.
into the next day, perhaps you can use your 20 minutes or so on something that is in contest.
Your Lordship, just to summarize that point,
Yes.
if I annexed the Gazette notice, that is 16th of August,
Yes.
and it specifically says that the sittings shall be held on Tuesday, 20th August 2024, commencing 9 a.m. until the conclusion of the business of the day. That is in
Yeah,
the
that is not in context. In
So,
context.
Your Lordship, let me quickly move to the next point that had an issue, Your Lordship. I'll go to the question of sub judice, Your Lordship.
Yes.
Your Lordship, the simple submission under sub judice or any matter for that fact that calls the attention of the Senate is that it must be raised as a preliminary issue before the Senate, Your Lordship. This is under Rule 14 of the impeachment rules, Your Lordship.
Yes.
Your Lordship, just by way of example, Your Lordship, the County Assembly raised preliminary issue, Your Lordship.
Yes.
Your Lordship, if you look at the Hansard of August 19th, 2024,
Yes.
at page 13, Your Lordship, of the I'm just trying to confirm whether it was the morning session. Of the morning session, Your Lordship.
Yes.
There is a part where Mr. Ndego Njiru, counsel for the County Assembly, makes the following remarks, Your Lordship.
Yes.
Mr. Speaker, sir, I seek your guidance and leave before we make our address on Rule 10 of the Standing Orders and Article 50 of the Constitution in respect to a preliminary issue that has arisen and Rule 14 as well, which states that any preliminary question or issue raised by the County Assembly or the Governor shall be argued for not more than 30 minutes unless the Speaker otherwise directs, Your Lordship.
Yes.
Your Lordship, you've been told that attention was drawn. In fact, let me use Councillor Ngoya's words. I hope I got them right. That was drawing attention by way of a letter, Your Lordship.
Yes.
Your Lordship, these rules were served on all parties, both the County Assembly and the Governor's side, Your Lordship. On 14th of August, Your Lordship, I've done it in my narration of the facts.
Yes.
Your Lordship, those rules are the rules that govern this impeachment, Your Lordship.
Yes.
And in any case, Your Lordship, this is not the first time that the Governor is coming for the impeachment. He understands these procedures, Your Lordship, that a preliminary issue will be raised, Your Lordship. So when that preliminary issue was raised, I'll just quickly go to the next page, which is page 14, after the page 13 I have made reference to. That is when counsel for the Governor, my senior Mr. Elisha Ngoya. Now, this is, I'm looking at the Senate Hansard of August 19th of 2024. Now I'm going to page 14, the morning session. Your Lordship, when counsel was given the chance, he actually just responded to the issues raised by the County Assembly, Your Lordship. He never made any mention about the sub judice and all of those things, Your Lordship, for purposes of the Speaker making a determination as a preliminary issue, Your Lordship.
You seem to be having different references, which is the change I'm having, because page 14 that I have would have a different story. We have a certified copy of the answer here. The page 14, my apologies for that, I didn't understand. Because if you look at volume 1A, which is a certified copy of the answer, so just check. Yeah, I'm there. That's page 14 now of the bundle. My apologies for that. I'll bring an affirmation of it.
Your Lordship, as I was continuing,
Yeah.
counsel does not raise any issue for purposes of it being considered by the Senate, Your Lordship. And Your Lordship will bear in mind that the question of sub judice is not a question for the respondent to determine on his own, Your Lordship. It is a question to be put before the House as a preliminary issue, Your Lordship.
Yeah.
Now, Your Lordship, that having not been mentioned, towards the tail end of the proceedings, and particularly on the governor's closing submissions, is when counsel raises the issue of sub judice at the tail end of the proceedings, Your Lordship. At length, on Friday, counsel brought to your attention the exact words he used, Your Lordship. But what you are not told is that happened at the tail end of the proceedings, Your Lordship, at the closing submissions of the governor, Your Lordship.
Yes.
Equally, Your Lordship, you've been told that Senator Halwale raised a point of order about the issue, Your Lordship.
Yes.
But Your Lordship, that issue is being raised at the time when the Speaker has put the question, Your Lordship. And Your Lordship, the rules of the Senate particularly Standing Order 96 of the Senate Standing Orders,
Yes.
provides that no senator shall speak to any question after the question has been put by the Speaker, Your Lordship. And in the same regard, Your Lordship, you will have time to look at the answer.
Is that it was the respondent's role to determine whether to allow the objection.
Yes, Your Lordship, the question here is, I think the time, because the time when this issue is raised. Remember, Your Lordship,
Yes.
when in the application of Standing Order 1035, this is after the matter is before the Senate, Your Lordship. When the matter is at the floor, where the Speaker has to make a ruling, Your Lordship, it has to be raised, not in his private quarters or capacity,
Yes.
receiving a letter and then proceeding to decide that yes, this issue. These are questions for the Senate, Your Lordship. And the Speaker is empowered in that sitting, Your Lordship, not in his office or somewhere else, to make that ruling when the issue is raised before the Senate, Your Lordship. That is our submission.
So the last is where the court situates the impeachment rules. Are they part of the standing orders, subordinate to the standing orders, parallel to the standing orders?
Your Lordship, it is part of the standing orders. In fact, if you look at the rules,
Yes.
in the schedule, for instance, I'll refer to second schedule, which provides for the rules of the standing orders, Your Lordship, which provides for the rules of procedure for removal of
the president
by impeachment.
Yes.
It actually quotes Standing Order 78-9.
It's a wider question. What happens generally? So let's just look at an act of parliament.
Yes.
What happens if the schedule and the substantive section of the law, where it derives its power from, its authority, are at cross purposes? So can the schedule derogate from 103?
I do not think so, Your Lordship. In fact, in my view, the same way we interpret the Constitution,
Yes.
the document should be read as a whole, with no single provision trying to host the other or sort of circumvent the other, Your Lordship. Our position is that these rules must be read as a whole, Your Lordship, not in isolation.
Okay. Thank you.
My Lord, perhaps I can add some context into that.
Yes.
My Lord, I don't know the exact provision of the Senate standing orders, but given a chance, I can refer the Honorable Court to it. The rules generally become that any rules made, there are committees in either the county assembly or the senate that deals with rules, any rules made must be appended to the standing orders. So the rules themselves, they are an intrinsic part of the standing orders. They are never read in isolation of the standing orders.
So the county assembly was to have 1 hour as well. Just a moment, let me reset the time. Yes.
Yes, my name is Mwangaza. I begin from the first issue that just to address what my landlord, Mr. Ukele, submitted on. The issue of the orders that are sought in this petition, my lord.
Yes.
You will note that the orders that are sought seeking to quash the decision of the Senate. Then there is order number H, prayer number H, a declaration that the Senate, yet the Senate is not supporting these proceedings, my lord. And I think Council referred you to the other prayers where declarations are equally sought against the Senate and some even extended to the Assembly. My lord, the point I want to make is that contrary to what I think the petitioner is an authority they referred to previously.
Yes.
There is Speaker of the National Assembly versus Center for Rights, Education and Awareness, which is a court of appeal decision.
Speaker of the National Assembly versus
Center for Rights, Education and Awareness. It's a 2019 decision, my lord. In that decision, my lord,
yes.
the speakers of both houses, that is the National Assembly and the Senate, have been sued. And I remember my learned senior, Elisha was submitting on this issue.
Yes.
Extensively, and his position was that when the Speaker of the Senate is sued, it ought to be taken that equally the Senate is sued. That authority, my lord, is distinguishable from the matter at hand. Because if you look at paragraph 17, I believe paragraph 17 of that decision, my lord,
Yes.
all the orders that were granted by the High Court, that is Justice Mumbi Ngoge, were orders directed to the Speaker of the Senate and the Speaker of the National Assembly. There were no orders issued against the Senate because the Senate was not a party on that matter, my lord. Moving on, my lord, I think it is important that I point out the documents that the Assembly will be relying on.
Yes.
My lord, we filed a replying affidavit. The fifth interested parties replying affidavit sworn on the 16th of January of 2025, together with the index of annexures, that affidavit.
Yes.
The submissions dated the 11th of February of 2025, together with the list and band of authorities that are filed alongside the submissions, my lord. And at this moment, my lord, I seek the assistance of your court assistant. That is the entire band of documents that the Assembly will be relying on. Perhaps they can be distributed to the desk for ease of reference.
Yes, yes. So that when you go back to your respective clients, in case they ask you why Mwamuye J is taking 21 days to write a judgment, perhaps you can mention Mwamuye J will go past through more than 10,000 pages. It is more than 10,000 pages.
We sympathize with you, my lord.
Yes.
My lord, I will foremost begin by explaining the impeachment process. My Lord, the impeachment process begins with collection of signatures at the Assembly.
Yes.
Standing order number 65 of the County Assembly standing orders. And this, my Lord, is
Standing order number?
65, specifically 6501 of the County Assembly standing orders,
Yes.
which are to be found on pages, a specific page is 1678, page 1678, in
Yes.
the next chair marked as JK 41D.
Yes.
My Lord, once the intended mover collects meets the thresholds, that is, they are that of the members of the Assembly, and the Speaker approves that motion, it is then tabled on the floor of the House.
Yes.
And pursuant to Standing Order 65-2, the mover gives 7 days notice calling for the impeachment of the governor. Pursuant to Standing Order 65-3, my Lord, upon the expiry of the 7 days,
Yes.
the motion is placed on the order paper and disposed of within 3 days. So, my Lord, the entire time that the County Assembly has, right from filing that motion with the office of the clerk, to giving notice, to consideration and passing a resolution,
Yes.
either in support of or to defeat the motion, is 10 days. 10 days is the maximum amount of time that the County Assembly has. That upon approval, if that motion succeeds at the Assembly with the 2/3 threshold,
Yes.
that resolution is communicated to the Speaker of the Senate within 2 days, pursuant to Section 33 of the County Governments Act, my Lord.
Yes.
And the Senate convenes, the Speaker of the Senate convenes the Senate to consider that motion.
Yes.
So, my Lord, the role of the Assembly is to initiate the impeachment process.
Yes.
My Lord, the decision in Martin Wambora, that is Civil Appeal number 21, it is in our list and bundle of authorities at page 111, spilling over to 112.
Yes.
This decision, my Lord, by the Court of Appeal, holds that the role of the Assembly is to initiate the impeachment process.
Yes.
And, my Lord, if I can read verbatim, there are 3 sequential steps to be followed. First is initiation of a motion to remove the governor by a member of the County Assembly. Second is consideration of the motion and a resolution by 2/3 of all the members of the Assembly.
Yes.
And that the Speaker of the Assembly is to forward the County Assembly's resolution to the Senate for hearing of the charges against the governor. So, my Lord, what is the role of the Senate? We submit that the role of the Senate, my Lord, pursuant to this decision, is to hear the charges against the governor. Section 33 of the County Governments Act, my Lord, and Rule 2 Rule 2 of the Senate Rules of Procedure
Yes.
equally provides that the role of the Senate, my Lord, is to investigate the charges and to determine whether the particulars have been substantiated. once Senate considers the impeachment charges, my lord, and makes a resolution,
Yes.
the dispute might find itself to court, as we have found ourselves, my lord, before you. The question that then arises is, what is the role of the court?
Yes.
My lord, we submit that the role of the court is to review the processes at the Assembly and the Senate to establish whether individual rights of the petitioner have been violated. Ordinarily, my lord, that would be the role of this court. But my lord, this is no ordinary petition.
Yes.
Because the petitioner, my lord, does not complain about the processes at the Assembly. My lord, I'll refer you to the further affidavit.
Just a moment.
Can I proceed, my lord?
No, just a moment. Yes, proceed.
My lord, I refer you to paragraphs 91 and 92 of the petitioner's further affidavit.
Yes.
My lord, I'll read verbatim what the petitioner says. Imperative to note is the fact that the amended petition does not at any point make any allegations against the County Assembly of Meru, and neither are there any relief sought against the fifth interested party, which is the County Assembly of Meru, as per its assertions and the paragraph of its affidavit. That paragraph is omitted. At paragraph 92, my lord, the petitioner goes on to say as follows: I could not help to note that the fourth, fifth, and sixth interested parties, through their responses, have framed a new cause of action against them and sought to respond on the very extraneous issues unrelated to the issues raised in the amended petition. If you turn to the next page, my lord, at paragraph 29, the petitioner deposed as follows: there are notable fact and distinction is that the cause of action in the instant petition arose at the Senate and not at the County Assembly. My lord, what is this court supposed to make of those words, those depositions by the petitioner under oath?
Yes.
My lord, the petitioner has made no allegations against the Assembly. The petitioner seeks no reliefs against the Assembly. The petitioner does not complain about the processes of the Assembly.
Yes.
And even faults the Assembly for responding on what she calls extraneous issues that are unrelated to this petition. So, my lord, as you exercise your role, as you sit as an arbiter over this matter,
Yes.
we submit, my lord, that your role is only limited to reviewing the processes at the Senate and not at the Assembly.
Yes.
My lord, the province of this court, as we are told, is Martin Nyaka Wambora. I'll take you back to the authority, my lord.
Yes.
Martin Nyaka Wambora, page 112, paragraph 32, tells us that the province of the court is solely to decide on the rights of individuals and not to inquire how the County Assembly and Senate perform duties in which they have discretion. Well, in our case, it is only the Senate, not the County Assembly, because there are no allegations. The petitioner complains not against the County Assembly, and therefore your role is only limited to the procedure at the Senate. Well, if you look at the amended petition, who are the parties? It is Honorable Kawira Mwangaza's petitioner by the Speaker of the Senate. The County Assembly is a party, my lord. I believe this is uncontested. We became a party on account of the oral application for waiver on the 18th of September, on the 18th of December, my lord. Sorry. My lord, if you look at the authority, at the decision in Martin Nyaga Wambora, Civil Appeal number 21, is appearing on page 104 of the Assembly's list and band of authorities. The County Assembly was the 6th respondent.
Yes.
If you go to Sonko, my lord,
Yes.
just a moment, my lord. The decision in Sonko, my lord, the County Assembly was the third, Nairobi City County Assembly was the third respondent.
Yes.
The Speaker of the Nairobi County Assembly was even sued as the second respondent. Unlike in these two cases, my lord, the petitioner has no cause of action against the Assembly, and therefore, my lord, it must be that in exercising the jurisdiction,
Yes.
the petitioner has confined you to the processes at the Senate.
Yes.
My lord, what is the review jurisdiction of this court? What is the remit or the extent of the review jurisdiction by this court? Our position, my lord, is that the jurisdiction of this court does not extend to a merit review of the decision or the resolution by the Senate. For now, we are not bothered with the Assembly, just with the Senate. Because, my lord, if this court, my lord, was to conduct a merit review
Yes.
of the decision of the Senate, this court would be supplanting its own decision, substituting the decision of the Senate for its own.
Just a moment. Let me take your time off. Let's go to the amended. Let's go into the amended petition, and we can look at the prayer. I'm interested in prayer number I.
Prayer number I am there, my lord.
Yes, please.
Yes.
An order of Sachi-Orarai it's been spelled the way we should pronounce it, to remove this honorable court and quash the decision and or resolution of the Senate made on 21st August 2024 resolving to remove the petitioner from office by way of impeachment. That was initially a judicial review prayer, remedy, relief. Then it was constitutionalized. Can that be issued in a procedural case?
Indeed, my lord.
So,
If I can explain, my lord.
yes.
This court, in reviewing the procedure as a Senate, if this court was to find, my lord,
Yes.
that the rights of the petitioner were violated,
Yes.
by way of example, if this court was to find that the petitioner was not afforded an ample opportunity to present a defense, that's a violation of a right to fair hearing,
Yes.
this court can quash that resolution.
So let's look at the previous prayer, which is prayer H. It is declaratory in nature, though.
A declaratory, that is order number H?
Yes, H.
Yes.
Please read it.
A declaration that the Senate, in its evaluation of the impeachment proceedings before it, failed to properly assess each of the specified grounds and determine if they collectively or individually constituted gross violation of the Constitution, warranting the removal from office by impeachment of the governor. Hence, the resolution of 21st August 2024 does not meet the threshold for impeachment set out under Article 181 of the Constitution. Hence, the same be and is hereby certified.
To the fifth IP's mind, is that merit or is that procedural?
That is merit, my lord, and that is why we invite you.
Okay, so your time is back on.
Yes, my lord. My lord, those two prayers, foremost, are sought against the Senate, which is not a party. I think it is important that we clarify that. Two, this is an invitation, my lord, for you to look into the merits of the decision by the Senate. An invitation we humbly urge you to decline. My lord, we find strength in that submission, my lord, in Martin Jaga Wambora, page 112 of our submissions, my lord, our list and panel of authorities. The province of the court is solely to decide on the rights of individuals and not to inquire how the county assembly and senate perform duties in which they have discretion. We find further strength, my lord, in the Sonko decision, paragraph 112, where the Supreme Court stated as follows, and I quote, likewise, in Justice Kariuki Mate and another versus Martin Nego Ambore and another Supreme Court petition number 32 of 2014, this court signaled that it would be reluctant to question parliamentary procedures as long as it did not breach the Constitution, and that the mandate of the courts is restricted by the doctrine of separation of powers to deciding on matters of individual rights and fundamental freedoms, and not to inquire into how the county assembly and senate perform duties in which they alone have discretion, or to review the merit of the decision by the county assembly and senate to impeach government. We submit, my lord, that you are guided by those two authorities.
Yes.
My lord,
I will record you are bound.
indeed, my lord,
Yeah.
bound is the word.
Yes, proceed.
My lord, in exercising that review jurisdiction
Yes.
to relook or to review the processes at the Senate, we submit that, my lord, in that very limited review that the petitioner has confined you to, in which, for the record, we have no problem with, this court, my lord, should also be aware
Yes.
that the role of the Senate is not to reassess the procedures at the Assembly.
Yes.
Such that, my lord, all the instances where the petitioner faults the Speaker of the Senate or even the Senate for not correcting what, in the petitioner's views, were errors at the Assembly, my lord, we submit that that is not the authority of the Senate. The Senate has no authority to review the procedures at the Assembly. Perhaps that is why, my lord, in that sequential or hierarchical separation of the distinct jurisdictions of all the three bodies, this court ultimately has the power to look at the procedures at the Assembly. The Senate does not have that power.
So let's assume that the county assembly, let's give a situation that would never occur.
Is my time point, my lord? Can I have a-
Yes, yes, it is. So the county assembly does not, there is no mover. They just go straight to the end. There was no vote, no nothing. Just the Speaker of the County Assembly forwards the decision to the Speaker of the August House. Are you saying that, and then it is raised as a preliminary issue? Are you saying that in that instance, the Senate would not be able to say there was such and such procedure established by the law and by the County Assembly's own standing?
My understanding is, one,
Yes.
that any grievances that ought to be raised at the Assembly cannot be taken on appeal. Such that, my lord,
Yes.
Senate does not sit on appeal of the decision by the County Assembly. The role of the Senate under Section 33, and also I believe Rule 2 of the Senate Rules of Procedure, is to investigate the charges and to determine whether the same have been substantiated. If